Greetings and welcome to this evening's Colorado Law Talk. My name is Georgette Vigil. I am the Senior Director of Alumni Engagement and Donor Relations at Colorado Law. We are happy that you are here. During the presentation, you can ask questions using the Q&A function at the bottom of your screen. Professor Rabea Benhalim will respond to questions following the presentation. Before we begin, I'd like to recognize that the University of Colorado sits upon land within the Ute, Cheyenne, and Arapaho Peoples territories. Further, we acknowledge that 48 contemporary tribal nations are historically tied to the lands that make up the state of Colorado. I'm delighted to introduce this evening's Colorado Law Talk, Oppression in American, Islamic, and Jewish Private Law, featuring Professor Rabea Benhalim. Colorado Law's mission includes providing exceptional legal education, engaging in critical thinking and research, producing influential scholarship with impact in the real world, and challenging the status quo. Many of our graduates go on to meaningful public service work which directly benefits communities and society. The Colorado Law Talk series was launched in 2017 to share research, knowledge, and ideas of the Colorado Law faculty with the broader community in the Denver area and beyond. Professor Benhalim, before joining Colorado Law faculty, was the 2017-2019 William H. Hasty Fellow at the University of Wisconsin Law School. She teaches various law courses, including contracts, secured transactions, and Islamic law. Her research focuses on two areas of inquiry: the development of Jewish and Islamic law in the modern era, and the application of Islamic law in commercial contexts. Her current work investigates how secular environments affect interpretations and development of religious law within these areas, especially for minority religions. She holds a JD from the University of Texas, an LLM from the University of Wisconsin Law School, and a Master of Public Policy degree from the University of Michigan, and a BA from the University of Texas at Dallas. In addition, she is a PhD candidate in Islamic Studies at the University of Texas at Austin. You can find out more about Professor Rabea Benhalim's notable background at the Colorado Law website, and I will put the link in the chat in a moment. Without further delay, I am pleased to turn the program over to Professor Benhalim.
Good evening. Welcome, everyone. Again, I'm Professor Rabea Benhalim, and the topic for today is oppression in American, Islamic, and Jewish private law, or maybe more accurately, how oppression is combated or negated or limited within each legal system within the realm of private law. As Georgette so aptly put, part of this inquiry came about for me because I teach contracts, and I also teach intro to Islamic law and intro to Jewish law. And so I had a real curiosity around how exactly each legal system deals with this issue in the realm of private law. Generally speaking, when we think about oppression, we think about public law. We think about what is the state doing. And so part of what I was curious about was, well, in the realm of private law, in the realm of transactions between individuals, most often happening through contract, what are the limits that jurists throughout history have really carved out, and why did they have those limits? For today's lecture, I'll be addressing a few thing. So first, why limit oppression? What do each of these legal systems say is the reason as to why we should limit oppression? Also, why compare them at all? What do I think is the benefit of comparing legal systems? We'll then move on to look at the exact tools available under private law under each system. So we'll look at American law, which will probably be the most familiar, I imagine, for y'all. So specifically, we'll be looking at duress and unconscionability. This might be like a flashback to your 1L year. If anyone's joined on who was in my 1L contracts class, welcome. At least a section of this should feel like a refresher. Then we'll move on to Islamic law and Jewish law and really look at the ways in which both of those legal systems also limit oppression and how they both compare and differ from the American legal system. Finally, we'll finish with the question of how could each of these legal systems learn from each other? What benefit might there be to adopting to certain elements of each legal systems into the other? And specifically, we'll be looking at the doctrine of economic duress in American law, the subjective standard applied in Islamic law, and then the concept of societal duties of Jewish law, and we'll really dig in there. So first, why limit oppression? So when we look at each legal system, we see three distinct reasonings for limiting oppression. Within the American legal system, we see that there's really this rooting of a justification for doctrines like unconscionability and duress in the need to preserve free will of parties and ensure that we actually have consent to contract. Within Islamic law, we see justifications really being rooted in a divine vision of an equitable and just society that's articulated in the Quran, and then we see how jurists moved on from there. And then finally, within Jewish law, we see that there's this argument for protections based on halachic duties, or duties within Jewish law, that require each individual to have an obligation to uphold towards their fellow humans. When we look at the actual texts themselves, the original source documents, we see within the Torah from Exodus, we have do not oppress the stranger, for you were strangers in the land of Egypt. And so there's this real argument against oppression that originates from this quote from Exodus. Within the Quran, we see, indeed, God orders justice and beauty and giving to relatives and forbids immortality and abomination and oppression. Again, a call against oppression. And then we get to the UCC, where we see the principles of unconscionability as one of the prevention of oppression and unfair surprise. So if you're wondering where I came up with today's title, this is where I came up with today's title, just noticing these themes of forbidding oppression, preventing oppression, limiting oppression across all three of these systems. Also, if you're wondering about my backdrop, I decided to leave this up today because these are the original notes that I created many moons ago for the paper that this talk is based on, and it's a forthcoming article in the Colorado Law Review. So I thought, given that these were the exact notes that I first scribbled up when dreaming up this particular topic, I thought I'd leave them up there for you. All right. Why compare legal systems? I am quite keen to this concept of something called juristic chemistry. And this is a relatively long quote from Roscoe Pound. And what we see in this quote is that the history of a system of law, so legal systems in general, aren't created in isolation. Legal systems fundamentally are a history of borrowing of legal materials from other legal systems and an assimilation of those various materials, and materials both within the law and outside the law. And there's a creative process that goes into this, that goes into the consideration of what are authoritative legal materials. We look at time, we look at place, and then there's a selection that happens. And part of what I'm arguing today is that I think maybe there's some selecting that should happen outside of our own legal system. And then there's this idea that this selection is a process of juristic chemistry, that the chemist does not make the materials which go into the test tube. He selects them and combines them for some purpose, and his purpose thus gives form to the result. And part of what the juristic chemistry is that I'm arguing for here today is to create a more just legal system, a legal system that prevents oppression both within the public and private spheres. All right, so first we're going to start out with the area that is hopefully most familiar to y'all, which will be tools available under the American legal system. First and foremost, we have the Doctrine of Unconscionability. So the Doctrine of Unconscionability seeks to ensure that a contract is the actual product of real bargaining, right? An actual bargain happened between two parties who had an actual freedom of choice. They had understanding. They had the ability to negotiate in a meaningful fashion. And there's two elements to this. Again, hopefully this is ringing some bells. There's procedural unconscionability, right? Then we might find that, in fact, we don't want to enforce a contract because there is some sort of issue ranging from undue influence to misrepresentation to mistake. And then there's this second prong of substantive unconscionability. And historically, this looked like relief and equity for mortgages, trusts, penalties. There was something within the contract itself, often around pricing, that courts found to be unfair. This eventually became encapsulated within the UCC, and UCC 2-302 has actually gone far beyond the bounds of what we typically think of for the UCC in terms of sales of goods. UCC 2-302 has been applied in non-sales and service contracts as it encapsulates this doctrine of unconscionability. So here we have the actual 2-302. If the court, as a matter of law, finds the contract or a clause unconscionable, courts can choose to not enforce the contract, right? Or they may enforce the remainder of it, right, without the particularly unconscionable bit. When it is claimed or appears to the court that the contract or any clause may be unconscionable, the party shall be afforded a reasonable opportunity to present evidence, etc. Right? So here we really have encapsulated this idea that if there's an unconscionable either element or the contract in total, there may be a cancellation in part or total of the contract. Determining unconscionability. Generally speaking, courts have found unconscionability in cases that involve gross, overall one-sidedness or gross one-sidedness of a term, right? Something like disclaiming a warranty, limiting damages, granting procedural advantages. The one-sidedness of the contract often involves some degree of procedural unconscionability that could look like buried terms, fine print, legalese. There's some element that a party is taking advantage of someone who would otherwise have moderate education, right? Someone who has, for instance, the ability to read, some sort of advantage is being taken of them. All right. Again, while a gross imbalance likewise consideration is often looked at by the court as well. So for instance, if there's a really gross imbalance in what the consideration for the contract would be, for instance, this can look like most often pricing. It won't be determinative in and of itself of unconscionability. However, again, this is where I was referring to pricing. That gross disparity in the values exchanged may be an important factor. That imbalance in bargaining power can also really factor in, together with terms that are unreasonably favorable to the stronger party. So if we have a power imbalance, one party is much stronger. When we look at the contract, we see that the more favorable terms are to the party that had the much stronger bargaining power. These can be indications that unconscionability may have been present. Give an example of several cases where unconscionability has been found. So for instance, we have a low income inner city area that offers major appliances for sale at a much higher price. A retailer offers credit to a customer, many of whom are not regularly employed, would not be granted credit through normal channels, and then the credit terms are exorbitant. So for instance, it looks like things like extremely high interest rates. Security is retained in all goods purchases, right? Even if there's very trivial defaults on those purchases. In this case, there was a welfare recipient. They'd purchased several items from the same store. They'd paid more than 2/3 of it. So they'd paid the majority of it. There was a small default. Everything got repossessed. There, the court found unconscionability because we see that both in terms of the bargaining power and then in terms of the actual agreement itself, there was a gross unfairness. I've included a few other cases, but I'm going to move past them for the sake of time and move on to the second element within American law on duress. So in the context of duress, so they're related but different doctrines. In the context of duress, although a party knowingly enters into an agreement, they don't do so freely. So they know they're entering into it. There's no question of having been duped into it. Rather, there's a threat of force. This is different than fraud, right? Fraud, we might have some element of trickery. Here within duress, there's a threat of force. And by extension, a promise has been made in response to this improper pressure. The classic duress case is a gun to your head. But as we will see shortly, it can expand far beyond that. The law of duress underwent significant development in the 19th and 20th centuries. It went from being a relatively weak doctrine that really only applied in those cases like a gun to the head to be expanded to a much wider range of cases where it would apply really to any wrongful act or threat which was determined to overcome the free will of a party. Historically, courts predominantly look to an objective test, although we've seen some moves away from that. And that objective test was whether a brave person would be put in fear or whether the will of a person of ordinary firmness, would be overcome. Today, courts are more likely to apply some degree of an objective test to see whether the particular coerced party's will was overcome. However, when it comes to cases involving economic duress rather than a physical threat, courts are much more likely to adhere to a strictly objective test. That moves us on to economic duress, which is a particular subset of duress. Under economic duress, a party uses illegal economic pressures to force a party to agree to demands such that the party would not otherwise have agreed to. These economic pressures can include things like demanding higher payment, threatening to breach a contract, either partially or fully. A defense of economic duress is most likely to succeed if there is an application of a good faith and fair dealing standard, and then it's determined that the party seeking the modification unfairly coerced the more vulnerable party. So there was a party that was in some state of vulnerability. In order for a party to prevail, three things must be proven. An ongoing contract actually exists between the two of them. The aggressor has threatened to cancel, i.e. not perform, breach in some capacity the contract with the aggrieved party, and the aggrieved party involuntarily accepted these new terms as they really didn't have any reasonable alternative. One of the challenges remaining in the doctrine of duress more generally is that threats used for an otherwise legal civil process. For instance, a threat to take someone to court. Because of a general public policy that favors free access to the judicial system, the doctrine of duress really militates against characterizing such threats as improper, even if the claim involved later proves to be without foundation. So this is one of the limitations that still exists and can create real challenges. All right, we will now move to tools available under the Islamic legal system, which I imagine probably will be fairly new to most of y'all. All right, so first and foremost, where do we even get this idea that we need to limit oppression within Islamic law? And we really find it first and foremost within the Quran. And we see several different lines from the Quran. First, "O you who believe, fulfill your contracts and covenants." So there's a certain understanding that contracts should be fulfilled. And then second, "O you who believe, do not consume each other's wealth or property between yourselves illegitimately, unless you undertake trading with mutual consent between you." So there's a concern around whether or not consent has actually taken when there is a trading of wealth or property. And finally, "Do not devour one another's possessions wrongfully, but rather by way of trade based on mutual agreement, and do not destroy one another." So again, there's this concern that there's an actual mutual agreement in contract and that there hasn't been advantage taken of another party. Given these Quranic verses, Muslim legal scholars have generally condemned bargains that they deemed oppressive and unfair. To achieve such ends, certain principles exist within Islamic law to help society guard against unjust practices. And there's a realm of principles that exist, but I'm going to highlight these. These include things like the doctrine of unjust enrichment, unfair dealing, contracts of necessity, and excessive speculation. And we'll tease out a few of these to see how they apply within context. First, we're going to talk about the doctrine of Riba. The concept of riba is commonly translated to mean usury. You might be familiar with this term within the context of Islamic finance, right? There's a prohibition against usury, and so Islamic finance has developed in particular ways. However, the concept of riba is actually much more broad. It literally means an increase, and it became an umbrella doctrine for all of the above concepts, the ones that I listed out on the prior slide, and served as a general prohibition on contracts in which one party received an undeserved profit. Based on that, it really got differentiated into two types of riba. Riba al-Fadl, in which a contracting party acquired an unlawful excess profit, and Riba al-Nasa'i, in which a party used contract terms to gain an unlawful advantage by speculating on uncontrollable risk. And so this looks quite similar in some ways to the substantive unconscionability we might find within the common law. There's a range of prohibitions that then emerge based on these two types of riba. So for instance, a usurer who loaned scarce money. So when there's a scarcity of money, they loaned it at a high rate. A person who bought crops and futures and advances, then hoarded them, then again sold them at higher prices in a time of scarcity, famine, and war. A landlord who leased his land to serf tenants and farmers on the basis of sharecropping or for fixed amounts of money or food grains paid to him in advance. A tax farmer who loaned money to powerful tribes, lords, or kings and exploited the poor tenants and serfs. And then a person in power over slaves or serfs, this is historical, who seized the appropriated earnings of his slaves and serfs. And so part of what you hopefully see emerging here is a concern with power differentials, at least in several of these examples. There's a real concern with the power differentials. And these concepts have been used to argue, for instance, in employment contracts where advantage has been taken from an employer to an employee. There's also prohibitions within Islamic law against coercion or duress. The concept of duress in both Islamic and the common law demonstrates an aim to set a standard of conduct by which people are expected to live. The two legal systems share a host of similarities in regards to duress. For instance, both systems differentiate between civil and criminal law. Today, we're concerned with the civil law, and in both instances, there's a higher standard of conduct in criminal cases. One of the big differentiations between Islamic law and the common law is the particularization of the law to a vulnerable party or to an injured party in duress. One of the central questions to the application of the doctrine of duress within Islamic law is how much particularization should the law account for? We see this also happening within the common law, but as I noted earlier, it's much more limited. So for instance, there's a question of should the law hold that the subjective feelings and fears of a threatened person are determinative? While there are certain rights of God and society that must be upheld no matter what under Islamic law is concerned with the particular subjective feelings of a coerced individual. For instance, the Hanafi scholar, and within Islamic law, there are different schools of thought. So the Hanafis being one school of thought. The Hanafi scholar, al-Sarahi, described the importance of taking the subjective feeling of a victim of duress as follows. We consider the preponderance of thought of the victim and what he felt, because the victim's belief takes precedence over the reality concerning matters that we have no way of verifying independently. So if there's no way for a court to verify independently the reality, then the victim's belief will take precedence. The condition of people vary according to their ability to withstand pain. Therefore, we have no alternative but to consider what the victim believed. So again, the court is not saying, oh, a person of, reasonable fortitude. Rather, they're saying, look, pain thresholds can really change. And if we're talking particularly about a threat of injury, that might really vary. The subjective experience of a victim is one element used to determine whether the victim is in fact felt threatened and is evaluated in conjunction with other elements. The Shafi'i school, another school of thought, divides threats to destruction of property into three categories. So for instance, threats directed against a substantial amount of property to the point that if the property were lost, the material well-being of the coerced would be effective. Threats of this level are deemed coercive. Threats involving an insignificant amount of property, not coercive. Threats against a significant amount of property whose loss would nonetheless not affect the material well-being of the threatened individual because of the latter's vast wealth would not be coercive. So you can see here part of the subjective determination that is happening. There are two opinions, there's two opinions in regards to this third category. One opinion does hold that regardless of the individual's wealth, the sheer amount of property is determinative. The other opinion, however, which is the one I just stated, holds that the threatened destruction can't be coercive because the substantive threat to the coerced individual was insignificant to them based on their actual wealth. Shafi'is also recognize another category with economic and social implications. This is the threat of public denigration. Such similar to defamation, could qualify as potentially coercive. The classical Shafi'i scholar, Mawardi, identifies two possible types of denigration. One is coercive, the other not necessarily so. And again, we see the subjective element playing in. If the threat is aimed at the quote rabble, aka deplorables, these are definitely older terms, people who do not condemn such behavior and among who insults does not lead to a loss of social position, then the threat isn't considered coercive. So it's not, if it's not an individual who has a certain social standing that would actually be lost, then it's not considered coercive. However, regarding threats of denigration against people of quote reputation or people knowing of chivalry, there's two opinions that exist. The first opinion holds that threats against these categories of people are coercive because of the pain of threats that public denigration would hold for them. However, there's a second opinion in these categories that people would remain unaffected by such threats because the other people in these categories would be aware that the coerced person was subject to unjust threats, and therefore such threats are not actually coercive. There's also a determination as to whether or not there should be an inquiry as to the background of the coerced individual. So for instance, what class of people they come from, at least within the classical Islamic sense. So for instance, they again have this interesting class of people that I don't think would apply in the common law system, but I find interesting nonetheless, which is a class of person who have their sights on the hereafter and therefore abjure any worldly concern. Mauradi argues that in the case of someone who is sort of identified as a holy person who has abjured worldly concerns, a threat to them that is of a worldly fame and status is not a fact a threat because it may actually elevate them and it would particularly elevate them in the hereafter. All right. So the Shafi'is are concerned fundamentally with the actual context of a case of duress. They want to look at whether or not the coercer was powerful, whether the threat was credible, and whether or not the coerce actually lacked any recourse. The Shafi'is don't go into the same psychological interplay, and I didn't have time today to talk about all the various psychological interplay of the Hanafis. The Shafi'is fundamentally still take into consideration the subjective impact of the duress on the coerced party through an evaluation of the coerced social standing, their particular fear, their lack thereof of the threat. For instance, and this is just to give you another category of how they look at subjectivity, if a threat is directed against people who regularly compete with each other in terms of how much pain they can endure, I don't know, thinking like professional mercy players, then the threat of a beating would not necessarily be considered coercive against such a person. However, everybody else, it would be considered coercive. At the end of the day, to sort of encapsulate the approach of duress within Islamic law, courts will look at such elements as a victim's age, their gender, their education, and the time and location that the contract was executed. The court will look at the specific ability of that victim to seek recourse. They might consider things like whether or not a victim was illiterate, whether or not the contracting party was in a remote area where they couldn't have gotten any advice, whether the threat was at night, etc. I see. All right. The final legal system that we'll look at are tools available under the Jewish legal system. And again, we see that within the Torah, there's these calls against oppression. Within Ezekiel, we see the people of the land have used oppression and exercised robbery and have wronged the poor and needy and have oppressed the stranger unlawfully. Likewise, the Torah also describes oppression or oshek in relation to the theft or withholding of a hired person's wages, which really echoes some of the things that we saw within the Islamic law section. The fundamental rule that we'll be talking about today is called the jesting rule. And bear with me, it's a little complicated. So here is the classic example from the Talmud. If a person running away from a prison comes to a ferry and says to the boatman, take a dinar, a coin, to ferry me across, he would still not have to pay him not more than the value of his services. The Talmud concludes that although the fugitive offers a dinar, which is more than the value, this offer is non-binding due to the exigent circumstances of the offer. The general rule for this is called the jesting rule. And it's based on this idea that an exploited party claims, so in this case, the person running away from prison claims, I was just jesting with you when I said that I would give you this exorbitant price. Curiously, the jesting rule is contrasted with a statement that then follows in the Talmud that says, But if he, the fugitive, said to him, take this dinar as your fee for ferrying me across, he would have to pay him the sum stipulated in full. If you are now scratching your heads, wondering if I had a typo, you go, that seems like it's in direct contradiction. Yes. So how did the Talmud sages resolve this seeming discrepancy between these two narrations that are right next to each other? So they explain it as follows. They say, okay, we realize this seems confusing. In the second part, the ferryman was in fact a fisherman who was catching fish from the sea, in which case we can surely say to him, you caused me to lose fish, amounting into the value of a zuz, so amounting into this increased value that he was charging. In doing so, the Talmud distinguishes between an individual performing the typical service of their job and an individual who, but for the provided service, would have earned a higher fee. This establishes the basic rule and exception that a contract is unenforceable in which the distressed party agrees to pay in excess of the regular price unless the other party can justify the higher than usual fee based on their typical labor that they have foregone in aid of the distressed party. A feature of these cases is that exploitative contracts often involve a person in distress. The Talmud does not differentiate between personal and economic distress. All right, so while the fugitive and patient, I did not include the patient case, I edited it out, described above have an individual, other cases involve economic fears. So for instance, it doesn't have to be just that you're running from prison. The Talmud describes the case of a widow who wishes for her brother-in-law to perform a certain ceremony that will then free her to marry whomsoever she desires. She promises to pay her brother-in-law to perform this ceremony, but after the brother-in-law performs it, she refuses to pay him. The court will then will accept her refusal to pay based on the fugitive and jesting rules. They say, yeah, specifically, there's a recognition that here there was exigent circumstances. She was not able to remarry until her brother-in-law performs this circumstance. Therefore, she's effectively in a monopolistic dynamic. There is a power differential here. Therefore, even though it's not the same as I'm literally running from prison, there is still exigencies of circumstance that are specific such that there's this monopolistic element. An additional element to these exploitative contracts is the consideration of whether or not the contract is atypical for the market price. So in the instance of the widow, normally the ceremony would be performed for free. So any price is atypical. Likewise, when we look at the person running away from prison with the ferryman, we'll look at what would the typical price for ferrying someone across be. Typically, exploitative contracts in Jewish law involve three elements: a distressed party, a semi-monopolistic supplier, and a different price difference from the market price. And that's just sort of highlighting that again. Okay. However, the jesting rule has been further applied and extended. So other commentators have interpreted the jesting rule as applicable to cases wherein the exploiting party would be committed to aiding the distressed party, even absent a contract. So Poskim have found the jesting rule to apply in cases where neither party is actually in distress, or at least not distress that would rise to the level of an impairment of free will. They're not even necessarily monopolistic or semi-monopolistic. Rather, this application of the jesting rule has focused on the substantive contractual fairness. And there's been a real focus on price fraud, and fraud really being expanded here as a concept. The focus on price fraud has expanded the application of the jesting rule to cases where the non-distressed party has a clearly enforceable legal duty. And the legal duties in Jewish law are quite more expansive than we would find under the common law. Or in the very least, we find that there is a religious commandment to aid the distressed person. So for example, the jesting rule has been applied to rabbis who charge an exorbitant fee to issue a bill of divorce. In these cases, scholars have referred to the rabbi who is charging this exorbitant fee as a thief and a coercer, because he knows that the bills of divorce may be given in his city only with his permission. And the one who must give a bill of divorce is forced to give him all he possesses. So again, normally a rabbi has a duty to issue these bills of divorce. But if the rabbi is not fulfilling the duty for which he has a clear obligation and is instead charging an exorbitant price for them, courts will say, no, that contract is void. While this example contains the elements of traditional application, scholars focus on the fact that the real focus here isn't so much on those traditional elements, but rather that the rabbi is charging for a service that he is morally obligated to provide. The jesting rule creates an obligation to assist distressed parties and a prohibition from exploiting that distress. So it does both of those things. There's 3 exceptions. So where alternate profits may be lost. So for instance, where the ferryman is also a fisherman, where the distress changes the type of service or the risk that the service entails, or where there is some prior investment in the required skills or availability. So this typically applies, for instance, to doctors, where they had to invest a lot of time in order to have those skills. Okay. Hanuk Dagan, in his book Unjust Enrichment, which is a seminal text, contextualizes these equitable doctrines as a general reflection of Jewish law as a commitment to the value of sharing. This value originates out of the social phenomenon of private responsibility in the Jewish tradition of tzedakah. Tzedakah applies when a defendant is in need and the use of the plaintiff's property or resources will not cause the plaintiff harm. He frames this approach as giving an owner latitude in striking the appropriate balance between the needs of others and those of their own. So for instance, they will look at whether or not there's a diminished value that has happened through the defendant's use. Tzedakah applies when a defendant is in need and the use of the plaintiff's property or resources won't harm the plaintiff. Harm is understood as a diminished value that might happen, but otherwise, for instance, you have an obligation to allow someone in need to use that property. And this approach really gives an owner latitude in striking the balance of their own needs and others. He concludes that the underlying social aim of Jewish law isn't an equal distribution of wealth, but rather providing relief for the needy or the vulnerable. In terms of, pardon me, there's a typo there. That should say sharing, Talmudic values of sharing. Dagan and other scholars have characterized this aim of Jewish law as being in sharp contrast with the American legal system. He characterizes the American legal system as preoccupied with the choice between the concomitant values of recovery of profits and fair market value, in contrast to the Talmudic values of sharing. His characterization focuses on the individualistic nature of the American legal system, where the demand of duty to aid a distressed person is typical of Jewish law, is foreign within the common law. Another scholar characterizes Jewish law as follows. In Jewish law, an entitlement, so for instance, an entitlement to property or even to enforce a contract without an obligation, is a sad, almost pathetic thing. And the role of obligations to others plays a huge role within Jewish law. All right, and now we'll move to the final portion of the lecture, which is protections against oppression in conversation. And really the question I'm posing is, what could each legal system learn from the others? And sort of like, what do I think again of the benefits of comparative law? Alan Watson, in his book Legal Transplant, says comparative law can be very valuable. It can have practical value. So for instance, when law reformers searching for better law for their own systems look at other solutions, it can have academic value. For instance, when a scholar has reached particular conclusions about a development in one system, can confirm the possibility of such a development by knowledge that something similar happened elsewhere. So that's part of what I'm posing today. And I'm not just posing it in regards to how I think the American legal system could provide better protections, but rather how each of these legal systems could learn from each other. So first, I want to talk about unconscionability applied within Jewish law. So this is a specific example from Jewish law where there's a disparity of power in the unilateral power of men to divorce under Jewish law. This unilateral power often leads to a process that can have unequal bargaining power between parties. This power disparity between wives and husbands in the dissolution of a marriage is often further exacerbated when the wife, for biological, religious, sociological, psychological, and economic reasons, is very eager to get divorced and remarried. Marglit argues that both American and Israeli courts should closely review divorce settlements emerging under these circumstances for substantively unconscionable terms. And Marglit argues that the doctrine of unconscionability should be adopted within Jewish law as a means of alleviating the unconscionability that can occur. Specifically, he says the common law doctrine of unconscionability could serve a variety of purposes, including retroactively canceling any unconscionable get settlements, so divorce settlements within Jewish law, It could also be used to address specific problematic conditions, such as the waiver of spousal entitlements, marital assets, continuation of the right of maintenance, aspects of child custody, and those really worst case scenarios. And Marguerite argues that the nature of traditional Jewish law is such that an unequal power of contracting parties prevails, even where the spouses at the outset of the marriage have privately regulated their spousal relations, and that the application of unconscionability from the common law could help alleviate this. Next, I want to talk about how Islamic and Jewish law might be applied within an American context. And I use a specific case here. It's from 1939, but it's still good law. And this is literally a quote from the case itself. So it involved a Black farmer in the South, Merritt Lewis, who had made statements that were true against the county sheriff. The county sheriff then threatened Lewis extensively. The court at first seemed to display some sensitivity to the particular predicament that Lewis found himself in as a person of color in the American South in the 1930s. And the court says, with an appreciation for the veneration and sometimes fear in which the high sheriff is held, especially by some members of the colored citizens in the Southern county, we can well understand how the plaintiff, when he began to hear the rumblings of the sheriff's wrath, could have become frightened and fearful of the consequences to himself. This is especially true when you consider that his two brothers were anxiously prodding him and urging him to make a prompt adjustment. The court, however, quickly changes course, stating that although apprehension on Lewis's part might have resulted in his signing notes, which but for the fear generated he would not have signed, does not measure up to the legal definition of duress as we have hereinabove found to be stated. And the court takes a distinct stance against the subjective experience of the plaintiff, stating the rule that duress must come from without and not from within, and cannot be a creation of the mind of the person claiming his will has been restrained by fear. Furthermore, the court ruled that the threat must be sufficient to overcome a person of ordinary firmness. The application of Islamic law in this case would have led to different outcomes. First, Islamic law would have taken into account the power differential, and I didn't have time to go into this aspect of Islamic law, but it takes into account power differentials between Lewis and the sheriff and would have applied Sadastri's analysis regarding commands or requests by superiors known for their injustice or oppression. Second, unlike the court's ruling in King versus Lewis, Islamic law would require an inquiry as to the subjective feelings of the plaintiff as to whether or not he was coerced. Rather than taking the perspective of the common law that duress must come from without, Islamic law considers, as noted earlier, the preponderance of thought of the victim and what he felt, because the victim's belief takes precedence over the reality concerning matters that we have no way of verifying independently. The condition of people vary according to their ability to withstand pain. Therefore, we have no alternative but to consider what the victim believed. In short, Islamic law holds that duress differs according to the circumstances of each individual. Islamic law would require a duress analysis that takes into consideration the subjective experience of an older, socioeconomically disadvantaged African-American man faced with threats by someone in police authority. Likewise, if we were to apply the jesting rule to this case, it would, I think, take a different outcome. If we applied the jesting rule, it would look to the duties the sheriff owed to Lewis, given his role as a sheriff. And applying the jesting rule, Jewish law would look to the legal duty, or at least the religious commandment that the sheriff had in upholding justice. The contemporary application of the jesting rule would not require that the distress Lewis felt actually rose to the level of impairing his free will. Rather, the inquiry would really focus on the duty that the sheriff owed to Lewis. Like the example of the rabbi who is deemed a thief and coercer because he knows that the bills of divorce may be given in his city only with his permission, the sheriff would likewise be deemed a thief and coercer because he knows that as a sheriff, he is the individual in the city who can maintain the peace and safety in Lewis's life or take actions that would result in Lewis's death. And then finally moving on to the application of the jesting rule and economic duress within Islamic law. While Islamic law has a concept of necessity that can lead to the voidability of a contract, necessity is understood as a distress that causes a person to procure an urgent and necessary thing that he has no option but to get or else encounter a serious danger. Both Jewish and Anglo-American jurists conceive of a more expansive notion of necessity. The doctrine of Ona or price fraud allows the application of the jesting rule to cases where the non-distressed person has a clearly enforceable legal duty, or at least a religious commandment to aid the distressed person. While Islamic law recognizes the impact a power differential between parties may have, Islamic law could benefit from adopting the Jewish legal framework of duties to situations where a religious obligation exists to aid a distressed person. Additionally, the common law doctrine of economic duress could expand the concept of necessity in exploitative contracts in Islamic law. The type of necessity present in the doctrine of economic duress is more attenuated than found in Islamic law. Islamic law requires necessity that is urgent, necessary. While Islamic law does recognize that certain types of economic threats, such as a destruction to property, could result in coercion, Islamic law typically requires an immediacy to these threats. Economic duress applies when the coercer's threats relates to a threat to cancel or breach an existing contract. The incorporation of economic duress into Islamic law would provide important protections for vulnerable parties, as it would also work in conjunction with the subjective standards of Islamic law. Finally, a history of a system of law is largely a history of borrowing of legal materials from one legal system and the assimilation of materials from outside the law, from Roscoe Pound. Unfortunately, there's often a presumption that religious legal systems have nothing to offer secular legal systems. The Islamic, Jewish, and American legal systems all have something to offer each other. By adopting aspects of other legal systems without a presumption of the perfection of a particular legal system, a better legal system, one with less exploitation and oppression, can be achieved. Thank you. I look forward to answering your questions. All right, and I am going to pull up the Q&A. Okay, so I see two questions. The first is from Harold Bruno. In Islamic countries, do they enforce their views of duress and unconscionability as we enforce the UCC and the common law? So it depends on the country and how they apply Islamic law. It depends on which school of thought they're applying. But in the article, which is that's forthcoming in the Colorado Law Review, I actually go through a case study from the UAE, and they certainly do enforce the doctrines of duress and unconscionability as I described under Islamic law within UAE civil courts. And for the most part, it's actually pretty similar to the UCC and the restatement, although distinct from them. There's something called the Majalla, and the Majalla is essentially a restatement of law that originated out of the Ottoman Empire, which is still applied in many Muslim majority countries when applying Islamic law. So yeah, I think that's the answer to that question. And then I see also a second question from Harold on who enforces Jewish law in 2022. So in terms of the application of Jewish law in 2022, we predominantly see two different forums. So the first is going to be certain forums within Israel, so within Israeli courts. So for instance, in Israel, we see that application predominantly happening within family law, within the family courts. And then, and this is what I write about a lot, is the application of Jewish law within religious arbitration. So there's a number of religious arbitral bodies that apply Jewish law. So for instance, the Beit Din of America, the BDA, has lots of arbitration that happens and specialized private mat. And pardon me, I had another thing pop up on my screen, and in a whole range of matters, including things like employment, private commercial transactions, and family law. The only area that we are not going to see, at least within arbitral bodies in the United States, is criminal law, right? Arbitration is always going to be a matter of private law, which is part of how I got curious about it. All right, who's got another question? Oh, here we go. From Jens Jensen, and pardon me if I'm not pronouncing anyone's name correctly. Have U.S. courts accepted choice of law provisions selecting Jewish or Islamic law? So this is like a whole thing I could give another lecture about. So it depends on the jurisdiction. It depends on, yeah, it just depends on the jurisdiction. So there was a whole like anti-Sharia movement, and which originated, if I'm remembering correctly, in Oklahoma, and I think now 26, I would need to review it, states have limitations on choice of law provisions, which were first framed as not allowing choice of law provisions specifically for Islamic law, which, like, no shocker, was unconstitutional. And so then that legislation generally got revised to not allow foreign law more generally. So there are plenty of courts that would still allow a choice of law provision for Jewish or Islamic law, but there are a number of states that have disallowed it. And it's a pretty broad, that legislation is pretty broad in not allowing foreign law more generally. But we certainly see cases, for instance, coming out of New York, so cases where you might see Islamic law as a choice of law provision. There's a number of cases that are pretty common. Texas, Michigan, and New York, I can easily think of cases where that was applied. Likewise, New York is going to be the predominant jurisdiction where we might see a choice of law provision for Jewish law being applied. All right, next question.
I'm pausing for a moment to see if you have any more questions, Professor Rabea. Well, seeing no other questions, I imagine you may receive some emails. Thank you, Professor Rabea Benhalim, for the enlightening presentation, and we appreciate learning. And thank you all for joining us.